there by the first one up on top of the hill there was, they could see it down by the road.
Yep.
Yeah, you gotta think about it, but yeah, you could see it when you drive. But that's just a shadow a little, you know, could have been a hot flying over here. Thing in there, we got about the same shadow, you know. You're already by it before you realize what it is.
Kevin just pointed out there's one sighted deer that would have quite a few hours right across the interstate.
Really?
Yeah, like right down
So
to.
a lot of people would be potentially exposed to that, or possibly sensitive,
I
something
think,
sensitive to it.
I think motorists that weren't expecting it might be more likely than, you know, potentially, I think people that live around them might be used to, you know where it's happening on the road. But, yeah, just-
Because on the road, if you're moving, and it would only be just a
I
short
thought
time
one
that would
time
be
I-
different than the deer running across in front.
I thought a tree was falling one time when after they first went up. It was startling.
Startling.
Yeah.
So one of the other immediate things that you, if the height, if the aesthetic impact from the bigger height is a concern, it's one of the immediate things that you could do that would be to also slap a height limit on. There's no existing height limit. It's lower than 650 as well. So. Put it at.
I guess I don't know if I necessarily put a height limit on. If the setbacks were sufficient, I don't think the height is much of a problem. I guess height's relative to how far away you are.
That's right.
I mean, if it's far enough away, it could be 1,000 feet high, not bother us. Where do we go from here to get something in place? So that we don't get caught short.
Yeah, so I need to know, you know, give me some things that you want brought back to you, I can help. With what you want to do.
I think the idea of having somebody that's knowledgeable about visual impacts, but I don't think that's necessarily realistic to do before we try to have something in place.
Oh, I guess it depends on, I mean, we're gonna have another meeting, and I'm assuming we're gonna have.
Yeah, we're still scheduled to have a regular.
So,
Yeah. Well, see if we can get somebody to address that before we act.
you know, I can see, I can see it, doesn't mean that something, you guys can check what you will do.
And then that would be somewhat limited, you know, and we probably would be beneficial to have some insight.
But I know that there was a guy, and there'll be a testimony in the Steuben project that, you know, that talks about the different level of heights. And you know how I talked about how the DEC stuff is based more on like forestry type versions? He was the guy that was talking about that.
Would
The
it be-
foreground, midground, and background are terminologies that have largely been developed for forestry type issues and how you perceive
Yeah.
trees and whatnot. And this is the guy that was really talking about that. I don't know if you'd be around, but they also know other people who, you know, will talk about it.
What if we just put Jim's suggestion down now as like a mile setback, and then if the company wants to pursue waivers, it's only 7 turbines, they would have to pursue 7 waivers. At least it would be, you know, something. would
Did you
be
set
in place.
the setback lower for a shorter, or, I was,
You were saying mile. for
I- I-
residents.
my thought was like a half a mile for something up to, probably the height of the existing ones, but anything above that, a mile, I guess. But I'm not opposed to
Right.
making it a mile.
I'm just
for
thinking if
any
we
of them.
wanna put something in place now, and then,
I guess,
or, it's hard, I don't wanna be subjective, but there has to be,
Well, you know, visual is sort of, I mean, I'm sure there's objective
yeah.
measurements for it, but I've kind of driven around and tried to think like, it's hard to, there's a lot of different factors that kind of play into it, but, you know, like, I go by, Blaine Knowles, and there's just that turbine up over the hill, and it's pretty close to the road there, but it doesn't really, I mean, when I'm driving by, that one doesn't seem as stark to me as some of the other ones where they're not like behind the hill a little bit or something like that.
that's why I say that the opportunity to address those individually with waivers is real, I think.
Right.
Because there's some of them that you see what, the top of the blade or something, and other ones you see from ground to the top, you know, that's big.
Like,
We work backwards from when we really need to have something in place. We don't have much time, do we?
there's not much.
There's gotta be a hearing. I don't know if it's something that's significant that like the hearing, a lot of times for local law, we just do the hearing
The
at the
county,
beginning of the board meeting. I don't know if that's realistic in this case, because I think if there's enough comments at the hearing, you want time to digest that and decide.
I would like you, me personally, I would like you to present what you want to present.
At a hearing?
Well, right now,
Okay,
whatever your concerns are, run with it.
okay, but I'm thinking of the process. The board has to pass the law, and there has to be a hearing before you do that. But it almost seems to me this is too significant to have a hearing at the beginning of the board meeting for 15 minutes and then make a decision.
We would have to make a motion to have a public hearing at the next meeting or at a meeting.
Or a separate
And
meeting.
then there has to be advertisement
Right.
before that, 5 days ahead of time.
But what Jim is saying, you don't wanna make the decision on that wind law that night without having time to absorb what the public has
It's
said.
up to the board. Three board members make that decision. So whatever happens that night, we could, you know, you get 2 yes and 3 yes and 2 no. You know, that's the way it
First of all,
goes.
we're not compelled to make a decision immediately following the public hearing.
Right.
Right, that's true.
Right, but I just wonder if you think it would be 2 separate things, a hearing on one day, not the same day as your normal board meeting, if realistically.
Well, having the law in advance to study before the public hearing is a reasonable thing, and then we would know what's,
you need it before the public hearing anyway. I mean, you
Oh,
gotta-
for sure, yeah.
of course, to just have a law plopped in front of us at a board meeting, in a
Right.
public hearing. There needs to be a presentation. I know we don't traditionally have a leader that makes any presentation, he simply says, public hearing is now open, and then silence.
How long would you want that proposed law
Well, we ought to have it.
available to the public also?
Well, yes, it has to be available to the public 5 days. When the filing is that there's going to be a public hearing, that filing says that the law is at the town clerk's office for the public to have. You know, more is better.
Yeah, that's what I'm thinking, it should be more than
Well,
that.
a couple weeks for us, but the law requires 5 days for the public.
The county planning department has to also approve a law like this, which,
They comment on it, do they have to approve it, or they just comment?
well, they can disapprove it, and if they do, then it at least kicks it into a supermajority of the board that would be
Oh.
required to pass it, so regardless of,
So that's, you're talking a
yeah,
month.
yeah, regardless of what their exact, powers end up being on it, they still have up to 30 days to review it. They don't take 30 days usually, but just for talking time-wise procedurally, that has to be baked in there somewhat, but usually you can get it to them, at the same time the public hearing is set or whatever.
But, okay, but, I mean, that gives me some idea that, I think if we want something solid by the 1st of May, we have to have something
Yeah, and
drafted by the
I
end
think
of
they're, yeah,
March.
yeah. Yeah, you have to, give it around.
Realistic. That's one more.
Yeah, I mean, if you, if you already know what you wanna do, I mean, we have had quite a few meetings, and you guys have thought about it a lot, you can get the numbers in there and, get them passed at the next meeting.
I don't know, I mean, Jack, you weren't here for the earlier discussion, but what we were basically saying is, we were talking about putting fairly significant setbacks in. There's waivers in the law that allow the wind company to negotiate on individual turbines if they, for some reason, can convince us that that setback isn't necessary, or they can make a non-participant a participant to meet the criteria, but to have something fairly strict in place with, I guess, maybe just a commitment to ourselves that we continue to review this with, maybe more information and more people, more expert. And, but just to have something in place so we don't end up getting an application without a modified law.
Yeah, I think it's important we get something in place, because of what we have in place now isn't gonna cut it,
No.
and the setbacks, I wouldn't have a problem with, and you're gonna wanna have them extended with the higher towers anyway, but I don't have a problem with that.
So, what's your thought, Robin? A mile, period? Or difference for different heights?
Ugh. So if we're not going to put any height limit, is that what you're saying? No height limit on the turbine?
We can, but.
Because we have to think there are 800-foot turbines out, down the road.
Yeah.
But again, if this is just like an interim, where maybe modified down the road. But I think a mile is a realistic starting point.
On a mile, I think you guys are probably gonna be going into the territory of
Being overridden.
yeah. The state has, their regs right now, I think at two times, so, 1,200 feet, or 13, it would be 1,300 feet at that, and then, so you would be bumping out to basically 4 to 5 times the state reg on that.
But the state doesn't doesn't have any 650-foot turbines yet. So,
Well,
That-
there's
that's-
600-footers, and there's a lot of 650s or 600 to 650 that have been permitted through the Article 10. It might be mostly 600s right now, but,
In residential
which
areas?
ones were those again? Do you know which projects those were?
well, basically, if you, since
Article 10,
yeah, the Article
Cass-
10 projects,
Most of those were,
most of those were larger turbines. A lot of the height regs before that were 600 though, so I don't think a lot of them are over 600. I think a lot of them are up to 600. But the regs though, the state regs don't have a height limit. They are based on the, yeah. So if you went, you know, if there were, suppose there were 500-foot turbines, then that actually makes the argument stronger that it's a larger, it's a larger multiple, because 500 times 2 is 1,000, and then, you know, a mile is what 5,200 and.
So we make it a half a mile up to 500 feet and a mile over 500 feet?
You don't think just increasing the height limit multiplier here?
No, because I think what I was, we talked about earlier, I don't think the visual impact is linear. I think it's geometric. When you go up 1.5 times the height, the impact is probably, who knows, 3 or 5 times as much. Personally, I think that's, I don't think it's just because it's twice as high, it's only twice the impact.
Yeah, I think that kind of makes sense.
Well, it does, it depends on how you're looking at it, because if you're looking, well, like, from my house to the turbines in front, I'm kind of looking into them, but up. If they were lower, I'd see more of them. If they were higher, I'd see less of them. So, you know, it depends on your
In the
vantage point.
individual situation, yeah. Yeah.
Depends on your vantage point.
Well, yeah, that's the other thing we were talking about, is the law gives the wind company the ability to apply for waivers. You could have a residence that fell within the, you know, the setback, but they can only see half the tower or 100 feet of it or something. And they might have a legitimate argument to have a, you know, a lower, you know, a shorter setback or whatever for that particular tower or something. I guess we were just taking the conservative route that
yeah.
until we have more information.
I understand, but I think when you're talking about a half a mile, even or a mile, you put that into feet, and it's
That's,
we're a long ways from what we're,
Yeah.
you know, what.
but it doesn't preclude the company from trying to get more participating landowners. I think that was Jim's main
That's the other
point,
thing.
is that it's on the company at that point to get more people.
The people that are gonna be most impacted,
Right.
they can make them participants, and that solves the problem.
I think that, you know, the town should do what it wants to do on how it wants to, and you guys should propose to the board how you want things to be set up. But I do think that if you go to half a mile and a mile, that it's basically, you know, it's gonna, I don't think the project will happen in Howard. So I don't think that they're going to, that the company will probably do, you know, be able to lock up all the land within a half a mile or a mile, because logistically, getting every single person to agree within that is, you know, there's gonna be plenty of people who don't want land, and if they're within a mile and they can go off, then I think they will. I think the cost of requiring this